Welcome everyone to Is Your Wellness Program Due for a Checkup? Thank you all for joining us. The team will be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we're unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday you'll receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'll hand it over to Carol Wood, Vice President and Counsel of Benefits Compliance at NFP, and Roger Abramson, Vice President and Counsel of Benefits Compliance at NFP. Carol, the floor is yours.
Thank you so much, Amber, and thank you everybody for joining us today. Good afternoon. We're excited to be with you discussing this important topic. My colleague and I, Roger Abramson from NFP's Benefits Compliance team, will be leading the discussion. Fortunately, we'll be joined by NFP's Wellbeing and Engagement team members, specifically Doreen Davis, Senior Vice President. She's in the Atlantic region, and Sarah Beth Hodo, a Senior Consultant. We're grateful to have them with us today to add their keen insights and commentary. Before we begin the presentation, I just want to remind everybody that it's for general guidance purposes only, and it's not intended as tax or legal advice. Any questions regarding the application of the law should always be addressed by your legal or tax counsel. The information presented is current as of today, October 16, 2024. Just to provide an overview of what we'll be discussing today, we'll start with a wellness program overview, attempting to define it, and then discussing group health plan challenges. Then I'll discuss the HIPAA non-discrimination rules. There are specific wellness program requirements for certain types of programs, and there's also been litigation, unfortunately, in this area. And then my colleague Roger will be discussing ADA and GINA considerations, that's the American with Disabilities Act, and the Genetic Information Non-Discrimination Act, and their application of those laws to wellness programs, and in particular the voluntary aspect. When is a wellness program voluntary? What are the requirements? Roger will also touch on other compliance aspects such as tax affordability and state law concerns. And then we'll wrap it up with some final takeaways and resources. So to begin, what is a wellness program? Workplace wellness programs today come in so many forms, so there really is no set definition. Generally, we're referring to some type of health initiative that's designed to maintain or improve the well-being of employees. There are measures such as health evaluations, education, coaching, diet and nutrition, exercise, and therapy. Wellness programs may specifically seek to help employees become tobacco-free, lose weight, manage disease, or achieve certain health-related goals. Alternatively, programs may be more generally aimed at promoting healthy lifestyles and encouraging employees to be more physically active. But before I go on further, I think it's best to engage our well-being consultants and let us know, what designs they're seeing today, really, what's trending.
Yeah, thanks, Carol, and thank you everybody for being on today. Really, over the past few years, we've seen a shift from those sort of traditional one-size-fits-all programs towards a more holistic, employee-centric approach. The most popular programs are designed with individual employees in mind, so they really empower them through choice, ease of access, and we see these programs typically delivered through some kind of hub or platform, right? Some kind of delivery model through which the employees are able to access a buffet, if you will, a menu of options. And these can touch on all different areas of well-being, from caregiving, financial fitness, stress management, sleep, nutrition, physical activity, mindfulness, you name it. So obviously, a robust version of this buffet sort of style would involve a variety of vendor partnerships, which we're going to get into in a minute. But we also see organizations take this same holistic approach from a grassroots effort as well. So it's really regardless of your capacity for formal partnerships, or your administrative appetite for a program like that. We found that simply enabling employees to choose how they engage with your well-being program leads to more meaningful impact.
Well, that is so helpful, Sarah Beth. I mean, I love the idea of something for everyone. But of
Right.
course, from a benefits compliance perspective, the critical issue with these programs, or perhaps components of the overall program, is whether they involve medical care. So what is medical care? Well, the regulatory definition, it's kind of technical. Medical care is defined to include the diagnosis, cure, mitigation, treatment, or prevention of disease for the purpose of affecting any structure or function of the body. Well, that sure is broad. Does this mean anything that affects any structure or function of the body is medical care? Well, no. The important issue in the analysis is whether the wellness program provides individualized diagnosis or treatment or prescription drug services for an employee. In some cases, the determination may be fairly simple. An annual physical or individual mental health counseling by a licensed healthcare professional is likely medical care. However, with these point solution, or sometimes they're termed add-on programs, they may provide medical care depending on the benefit specifics. And I did indicate we have a guide that outlines some of the criteria that employers should consider in determining whether these benefits provide medical care. Factors that you're looking at is, are the services provided by that licensed healthcare professional? Is the advice general for anybody with a specific condition or disease, or is it really individualized to that particular employee? And often these are through apps, and their guide provides some examples. So I think if you're an employer struggling with that, you might want to take a look at that guide. As I mentioned, a program that's only offering general recommendations, coaching, education, broad-based exercise activities, and one that's not individualized is likely not providing medical care. Well, why is it so important to assess whether the wellness program is providing medical care? Well, if it is providing medical care, it's considered a group health plan, and then it must comply with the applicable group health plan laws. These would include ERISA. We know they have ERISA's requirements include the plan document, SPD, Form 5500 filing, specific claim review process, fiduciary obligations, a real focus on that today, and much more. There's also COBRA with specific notice requirements and offers of continuation coverage. The ACA, and this is perhaps the most onerous, preventive care coverage, prohibitions against annual and lifetime dollar limits on certain benefits. There's HIPAA, of course, that applies to group health plans. We'll be discussing compliance with non-discrimination rules, but we also have HIPAA privacy and security rules, and you'd normally be having to enter a BAA with a vendor. And I would point out that employers should be sure whether in relation to HIPAA privacy or just data protection in general of your employees' data, to seek contractual commitments regarding a vendor's cybersecurity practices. The DOL recently issued guidance on this, making clear it applies to health plans and not just retirement plans. And I think this is very helpful tips for hiring a service provider with strong cybersecurity practices. For example, inquiring as to whether they have adequate cybersecurity insurance, asking if they've had a third-party assessment of their practices. That's often in a report, such as what's known as a SOC 2 report. So it's very important today. Well, if the program offers medical care, how do we satisfy all these group health plan requirements? Well, the simplest way is to, quote unquote, piggyback the major medical plan, offer the wellness program only to enrollees in the employer's major medical plan, which presumably already satisfies the ACA, COBRA, and ERISA requirements. Of course, you would still need to make some updates. You'd have to include the benefit in the plan documents and SPD, offer COBRA, etc. The alternative is to offer as a separate standalone benefit. You could extend the offer then to all employees, regardless of their enrollment in the medical plan. But of course, compliance may be challenging. For example, how will ACA requirements be met independently? One possible exception that may help is for some EAPs, but not for other programs. And with EAPs, there is an exception from ACA requirements. They'd still be subject to COBRA and ERISA for the portions of the EAP program that's offering medical care. But if it's determined that the EAP meets certain requirements, and the most pivotal among them that they're not providing significant benefits in the nature of medical care, they may not be subject to the ACA requirements. They may fall into a category that we call accepted benefits. And this is why you'll sometimes see a limitation. Let's say an EAP is offering mental health counseling, which of course is medical care, and they limit the number of visits. And the argument that they're trying to make is, we're not offering significant medical care, and thus we're not subject to ACA requirements. Can employers rely on wellness program vendors to advise on applicable laws? Well, the answer to this is no, because the employers are ultimately responsible for ensuring their wellness benefits comply with all laws. Benefits providing medical care are essentially in employers, if they're standalone self-funded group health plans. It's unclear whether medical care is involved. Then legal counsel should be consulted to help in making that determination based on the specific facts and circumstances. And you do want to make sure you address this issue up front before you enter a vendor contract, and try to address the specifics, really. How is COBRA coverage going to be provided? If a wellness benefit provides medical care without fully complying with the group health plan laws, then employers with their legal counsel are going to need to assess the potential risks. And I do want to ask our Wellbeing and Engagement team, do you come across this issue with employers, and what do you see them doing to try to assess and minimize potential risks?
Sure. Yeah, I'm really glad you brought this up, because I would say it is one of the more common questions or challenges that we are navigating right now, particularly that gray area around those accepted benefits and what that definition might look like. So I'll ask you to bear with me, because there's a lot to dissect here. But first, I would reiterate, as you mentioned, that the risk of assessing whether or not a point solution qualifies as medical care ultimately falls on the employer. So that's what we want to start with, right? And then also, as you mentioned, the simplest way to reduce that risk is to only offer those point solutions that provide medical care to medically enrolled employees. But of course, then the question becomes, what about everyone else, right? If we're truly interested in supporting the health and well-being of all employees, not just those who cost us in claims, how do we support everyone? So we're actually seeing some organizations tackle this with a tiered approach. Essentially, medically enrolled employees have access to the elements of a point solution that constitute medical care, while non-enrolled employees are able to access those non-clinical program benefits. It's relatively new. I've only seen it a few times. It can get a little tricky, so it's really important to work closely with vendor partners, legal teams, to clarify what can be offered to whom and how we stay within the parameters of these compliance regulations. I've actually asked many vendors under many different well-being categories whether or not they consider themselves medical care or an accepted benefit, and all but one has told me that they believe they fall into that gray area when interpreting the language of the law. So that means they are ultimately putting the risk back on the employer to decide. It can be helpful to ask vendors how the rest of their clients are treating their services. Do they have other clients offering their solution to all employees or just medically enrolled? How many? I think those questions, while they don't necessarily protect you, they can be important guidance. And from a legal team perspective, we know that you never want to be the first. You never want to be the precedent. So it can help to know how other clients are treating this dilemma. And then when reviewing those new or even renewing contracts with vendors, as you mentioned, it's ideal to engage that legal team to navigate this gray area. They can help you assess your organization's risk tolerance. They can make sure that there's language in the contract designed to protect you. Always approach a vendor contract assuming that the language is set to protect the vendor first. And don't be afraid to ask for term changes. I see this all the time. It feels like an organization just has to sign and agree to whatever that template language is, but that's not true. That contract review is your opportunity to request your own term changes, your own BAA, even to require notice if the vendor's interpretation of the law changes. And we found actually that vendors, particularly new ones, are very amenable to the red lines and contract negotiations. So the conversations that I'm talking about, they're not going to fully mitigate the risk, right? Ultimately, that does fall on the employer, but it can help you arrive to a decision for your organization that you're comfortable with. And I also recommend, in addition to working with your legal team, referencing that Point Solutions Programs Guide for helpful tips as well.
Thank you so much, Sarah. That was a lot of really valuable and practical insights into how employers are trying to address this situation today. And as a person who reviews and negotiates contracts, I can't agree with you more on the importance of really reviewing those contracts, engaging legal counsel if you need to, but working out the terms so that they're protecting you and your employees. And you really want to do that up front when you have that negotiating power. So super valuable tips there. Thank you. Okay, so we're going to be moving on now to be discussing the HIPAA non-discrimination rules. Now, HIPAA, of course, is a very broad statute. We've touched on already the privacy and security rules. We know there are also special enrollment rights, but our focus is going to be the non-discrimination rules, and in particular, their application to wellness programs. So what are these rules? The rules prohibit a group health plan from discriminating in terms of eligibility, costs, and benefits based on a health factor. That would be, for example, a health status, a medical condition, medical history, disability. Enforcement is by, I guess, the usual suspects, DOL, HHS, and IRS. But some wellness programs, of course, provide incentive based upon attainment of certain blood pressure or cholesterol levels. So you say, well, isn't this discriminating based upon a health factor? And the answer, of course, is yes, but there are exceptions, as there usually are with any rules, for certain types of wellness programs, those that satisfy the HIPAA wellness program requirements that we'll be discussing, programs that discriminate in favor of those with adverse health conditions, such as providing extra screenings or counseling for those with a heart condition, a form of reverse discrimination that's permitted. And additionally, some programs are not based on a health factor to begin with. Some wellness programs are what we consider to be just participatory. So what is a participatory wellness program? A participatory wellness program is one that doesn't provide or condition, as we said, a reward for the satisfaction of a standard related to a health factor. So an example would be taking a health risk assessment or undergoing an annual physical with a reward not tied to the results. Now, there may be other rules like ADA rules that apply, and Roger will be discussing those. Another example would be attending sessions with a health coach. What about a walking program without any distance or time requirements? The answer here is no. It's not considered participatory because some may not be able to complete it due to a health factor. Maybe they recently had knee surgery or they have respiratory problems. So what are the compliance requirements for a participatory wellness program? And they're relatively minimal if you can fall into this category. The program must be available to all similarly situated individuals. which means based on a bona fide employment classification, full-time, part-time status, occupation, geographic location, union membership, hire date, length of service, a current and former employee status. And these are very similar to what we're familiar with for our Section 125 non-discrimination rules, right? These bona fide employment classifications. Additionally, participants can be treated as a separate group from beneficiaries, meaning spouses and dependents, if the program's offered to those. And groups of beneficiaries can be treated differently from each other. With a participatory program, there's no set limit on the reward. The employer would determine. You can, of course, limit the group health plan eligibility based on completion of the wellness program requirements. And again, the EEOC wellness rules may need to be considered. We're just discussing the HIPAA rules in this section, and Roger will be discussing those in a short while. So what is the health contingent wellness program? So there's two main categories, right? We have our participatory programs and then our health contingent wellness programs under HIPAA. And under the health contingent category, then we also have two subcategories. So with a health contingent program, it provides a reward for satisfaction of standards related to a health factor. The two kinds are activity only, where activity only requires performance or completion of a physical or health-related activity to obtain a reward, but does not require attainment or maintenance of a specific health outcome. So an example would be a walking challenge, a diet or exercise program. With an outcome-based program, by contrast, this requires an individual to attain or maintain a specific health outcome. So perhaps they need to be tobacco or nicotine-free, have a healthy range of certain vitals, blood pressure, cholesterol, etc. And I'd like to ask our well-being consultants, which types of programs that they're seeing most popular today in terms of the HIPAA categorizations, and also are some viewed as being more effective?
Thanks, Carol. I will be happy to take this question. So we are definitely seeing a decrease in some of these outcomes-based incentive programs overall. There's been a shift happening, as Sarah Beth already referred to more holistic programs that offer a variety of activities across the full spectrum of well-being. So we're talking about not only physical health, but emotional or mental health, financial health, and social well-being as well. And when they do this, this allows employees to engage in a way that's really more meaningful for them versus the employer telling or even prescribing a specific aspect of health as the most important for all employees. So, for example, if we think about someone who might be struggling with mental health, as many people are, that might take precedence and perhaps should take precedence over their physical health in that moment, in that time. If an employer has an outcomes-based incentive program and that particular employee doesn't meet the health standard to earn that lower premium, that could really add to their mental strain. And I would also venture to guess that that employee probably doesn't feel super supported by their employer for that particular program. So I really encourage employers to think about, what are you trying to accomplish with the wellness program? And if the goal is to support employees' health and well-being overall, consider how your incentive design and how the incentive requirements is going to be received by the employees. Because I think that's an important aspect when we're creating that design. Think about how it's going to be received by employees and not just what you're trying to accomplish overall. And then when we look at activity-based programs, these are still very popular. So these are things, as you mentioned, like step challenges or other types of physical activity challenges. And these can be very successful in encouraging not just physical activity, but also fostering that connection among teammates, that social well-being aspect, which we love to see. So depending on the type of activity and the type of incentive that's offered, a reasonable alternative standard may be required for someone that can't participate because of a health condition, for example. And then last, participation-based programs, as you've mentioned, these are those that don't require any particular health outcome. Those are very popular as well. And this can look like a menu of options for employees to choose from. So things like preventive care completion, or even watching a webinar, completing a health assessment, participating in a financial wellness program, you name it. It could be any host of all different things across the spectrum of well-being. And so when we look at these outcomes-based programs, they're still out there, and that's perfectly fine. I don't want anyone on the call who might have an outcomes-based program to feel like they need to abandon it immediately. That's not the case. But I would encourage employers with those programs to offer additional opportunities for employees to engage in the program beyond just those physical health measures. And also be sure to actively communicate the reasonable alternative standard for those that don't meet that initial requirement.
Thank you so much, Doreen. That is so helpful. And we will be discussing the reasonable alternative standard in more detail, but that's a great idea of ways to really engage employees and not necessarily in an outcome-based program. They can still be very effective, it seems, from what you're saying. So very helpful to learn. Okay, well, let's just go back to the rules of what the compliance requirements actually are for a health contingent wellness program. One basic requirement is that employees must be offered the opportunity to qualify for the reward at least once per year. Now, they can qualify more than once per year. That's just a minimum requirement. Additionally, a reward must be limited to 30% of the total cost of health coverage. This would include both the employee and employer portion of the cost, and that would be 50%, a higher percentage for a tobacco cessation program. The program must be reasonably designed to promote health or prevent disease. And then the reasonable alternative standard must be made available. So the idea behind that is for those who can't meet the base standard, there's an alternative standard that's available to them so they can achieve the same reward. Importantly, notice of the reasonable alternative standard must be in all program materials, and there is model language available for that. So how does an employer, how do they exactly comply with this reasonable alternative standard or RAS requirement? And it can be, as opposed to an alternative, it can be a waiver as well. Again, it has to be provided to all of those who can't meet the base standard. Let's say the base standard is to be tobacco-free. It's not necessary to specify that alternative in advance, but the employer does need to provide notice that an alternative is available. And to whom it's available varies on the plan design. With the activity-only programs, the alternative has to be provided to those for whom it's unreasonably difficult or inadvisable due to a medical condition to achieve the base standard. Perhaps as a pregnant employee who can't complete the walking program. And the employer can require a doctor's note in such case. By contrast with the outcome-based program, the alternative has to be provided to anyone who can't meet the original standard for any reasons. So if the requirement is outcome-based, such as being tobacco-free, meeting certain biometric screening standards levels, then that alternative has to be provided to anyone for any reason. Under both types, the alternative has to be reasonable. The employees must be given the entire plan year to achieve that alternative. And if and when it is achieved, the full reward must be made available to employees, meaning an employee who completes, for example, a tobacco cessation program as an alternative standard would be entitled to premium adjustments going back to the beginning of the plan year. As we stated before, that alternative must be communicated clearly in all plan materials. And for you visual learners, here's the big picture of the HIPAA Wellness Program rules. Is the wellness program related to a health plan? Then we look at, is it participatory or health contingent? With health contingent, we look at the two subcategories, whether it's activity only or outcome based, and then we determine to whom in those two subcategories the alternative standard needs to be made available. So why are we driving home this reasonable alternative standard requirement so much? Why are we emphasizing it? Well, unfortunately, there has been a lot of litigation over this specific requirement, and particularly as applied to premium surcharge programs. The DOL has brought several cases. There was a lawsuit in 2023, and it was really over what the DOL claimed was the employer's failure to disclose that alternative standard, and the employer had to reimburse participants and pay some monetary penalties. Just very recently, there's a new series of lawsuits, and these are brought by employees against employers in relation to tobacco and also vaccine premium surcharges, and alleging that the employer is violating the HIPAA non-discrimination rules because they're not providing the full reward if they complete, as we said, let's say a tobacco cessation program. They can't just apply that lower premium prospectively, right? We have to go back to the beginning of the year. No, they're not communicating in all program materials. So employers who do have particularly a tobacco or vaccine surcharge will want to look at their programs carefully for compliance. I also want to just provide an example. This is a frequently asked question that we get regarding just really the implementation. Like once you have this wellness program in place, let's say it is a tobacco cessation program, do we fully understand how it's implemented and to be able to fairly and effectively carry out what the employer's goals were for the program. So the question here is, there's a calendar year medical plan on the client saying we have a calendar year medical plan and it has a premium surcharge for tobacco users. To pay the lower rate, employees must certify at enrollment they have been tobacco free for 6 months. A tobacco user told us in July that she's been tobacco free for 6 months. Should we adjust her premium rate? And Doreen, I'm going to throw this one to you and let you answer to me as the client, okay?
Sure. Yeah, that's a great example, actually, Carol. And just to reiterate, our goal is always to keep our clients out of the news with any of these lawsuits. So we do want to make sure we're being very careful here. The answer is it's going to start with the one that's going to probably make some eyes roll. It depends, but it depends on the program design and whether the employee satisfied that reasonable alternative standard. So let's say the employee didn't meet the base standard, so they use tobacco products currently, and they are still entitled to that same reward, which is the lower premium for the entire year, if they satisfy that reasonable alternative standard, which would theoretically be a tobacco cessation program. However, if an employee comes forward during the year to say that they've quit, but they did not complete the reasonable alternative standard or participate in that tobacco cessation program, the employer is not required to give that full reward, which would be that lower premium for the entire plan year. However, if the program allows an employee to satisfy the base standard more than once per year, which once per year is that minimum requirement, then they could be entitled to that lower rate. So in that case, the employee would complete a second tobacco attestation, submit it to HR, and then that would allow them to be eligible for that lower premium from that point forward. Now, I would encourage to employers with this example specifically to think about the goals that you're trying to accomplish with your tobacco incentive or your tobacco surcharge, because the regulations around this can be a bit counterintuitive if we're being honest about it. So, for example, the person who completes the tobacco cessation program but did not successfully quit using tobacco is actually entitled to the full reward, that full plan year reward. But the person who quits using tobacco without taking the tobacco cessation program or completing the tobacco cessation program, they're actually not entitled to that full reward for the entire plan year. Again, that feels kind of counterintuitive, right? We're trying to encourage healthy behaviors, and in this case, not using tobacco. So, with that in mind, you really want to consider your plan design, consider that reasonable alternative standard carefully before you implement the program so that it can be administered consistently with whatever scenario might present itself from your employees. And I would also encourage employers to include the instructions on that tobacco attestation, whether it's a form that's being filled out or if it's embedded in your open enrollment system. Include the instructions for someone whose tobacco status might change during the plan year if you're going to allow that. That way, no questions can be asked around whether it's a possibility or if somebody quits during the year and they come to you, you've thought about it in advance and you know what your response can be. And then the last thing I want to reiterate is really make sure that you're communicating that reasonable alternative standard in all of the program materials. So even in the tobacco attestation, you can put the language in there. If you post a flyer before open enrollment and it talks about the tobacco surcharge, it needs to be listed on that flyer. If you send out emails, obviously, every piece of communication that talks about that incentive or that surcharge needs to include that RAS language as well to be on the safe side.
Thank you so much, Doreen. We appreciate those insights. And yeah, I think it's just so important that employers really consider the design aspect and how it's going to be implemented very carefully when they set the program up initially, so employees are treated consistently. But with that, I am going to now turn the rest of the program over to my colleague, Roger, and he's going to start by discussing the ADA and GINA considerations with respect to wellness programs.
Thank you, Carol. As we just heard Carol talk about the HIPAA rules for wellness, which are the ones most people are familiar with, at least in terms of their existence, there are a couple of other federal laws that kind of sit out there that sometimes get a little overlooked. And they are, of course, the Americans with Disabilities Act, also known as the ADA, and GINA, the Genetic Information Non-Discrimination Act, which has been sometimes forgotten in a lot of ways, and we will address that here. Regarding the Americans with Disabilities Act, as most people know, the ADA prohibits employment discrimination against individuals with disabilities in terms of employment, compensation, benefits, and so on. And that is enforced, the ADA generally, by those provisions by the Equal Employment Opportunity Commission. So it limits employers' ability to make disability-related inquiries or require medical exams unless they're job-related. A disability-related injury or inquiry, is a question or a series of questions that is likely to elicit information about a disability, including but not necessarily limited to questions about impairments, workers' compensation history, and prescription drug use and the like. So wellness programs that include disability-related inquiries, again, for example, as part of a health risk assessment, medical history, or require medical exams, for example, annual physical, biometric screening, and so forth, must follow the EEOC ADA wellness program rules. We'll address those momentarily, but in the next slide, I'll talk about GINA. GINA was passed back in 2008 and shares with mental health parity the MAPIA Act, which was also passed in 2008 as part of to fix issues with the Mental Health Parity Act from before. Two major pieces of federal legislation that affect employee benefits, and yet we're overwhelmed in terms of the new shiny object, which is of course healthcare reform, became the ACA just in the next year, and they didn't get forgotten. There's just so much going on that they're here, and some people forget a lot about GINA, which was a very big deal at the time. At any rate, as its name suggests, GINA prohibits discrimination based on genetic information. We have a Title I and a Title II. So Title I, first section, prohibits group health plans and insurers from collecting genetic information for underwriting purposes. That is defined broadly and includes wellness reward eligibility. That part's enforced by the magic triad, of course, HHS, DOL, and Treasury. Title II makes it an unlawful employment practice for an employer to request or require an employee or a family member to provide family medical history or other genetic information. That part is enforced by the EEOC, same agency we just talked about for the ADA. Genetic information is defined broadly and includes two categories. The first being family medical history. Some people forget about that. They think genetics, they think genetic tests and so forth, but family medical history from a biological family is by definition genetic information. And that includes current medical information of spouses and dependents, and of course, genetic tests involving analysis of DNA, RNA, etc. So moving to the next slide, how does GINA impact employers and wellness programs? So GINA places prohibitions and restrictions on requesting and requiring family medical history, genetic testing of individual or family members. Notice family members keep coming up. Family members keep coming up in this with GINA for obvious reasons, including prior to or in connection with enrollment. For instance, can't ask an enrolling employee if they or a family member had cancer, heart disease, etc. Also setting premiums or contribution amounts, for instance, premium reductions based on genetic information. Now, that means, of course, these restrictions can make it challenging, to say the least, to design a wellness program that involves a request for genetic information, which again is not just let's take a blood test and look at your DNA and RNA. It includes a health risk assessment that include the typical questions we're all used to in the doctor's office and so forth, questions about the medical history of the employee's family. But Title II, just like with the ADA, provides an exception for wellness programs that meet EEOC GINA wellness program requirements. So here's our big five. EEO wellness rule requirements, which broadly speaking apply to these ADA and GINA restrictions, with a couple of exceptions we'll talk about. So first of all, we have to be talking about a program that must be reasonably designed to improve health and prevent disease. In other words, it needs to be some kind of wellness or well-being program. There has to have modifications or adjustments might be needed, sort of a variation of the reasonable alternative standard we talk on the HIP end, not the same, but in the same neighborhood, might be needed to accommodate disabilities. Remember that word accommodation, which anybody who's dealt with ADA should be familiar with that general phrase. There should be, or there is, a notice requirement with an extra bonus for GINA in terms of authorization, not just notice, but I thank you for the notice of what you intend to do. I can't let you do this until I authorize you to do that. We'll talk about that in the next slide. But the last two are the harder ones. Participation must be voluntary, and there's restrictions on reward amounts. We are awaiting revised guidance, and we'll tell that little exciting story in a couple of slides. But next slide is the notice requirement. So under ADA, notice content delivery has to give notice of what type of information is obtained, how it will be used, restrictions on disclosure, methods used to ensure medical info isn't properly disclosed. You'll see some very rough, broad analogies with HIP information here. The notice is due before the medical inquiry is made. You can't make the medical inquiry and then a couple weeks later go, here's some notice of something that happened 2 weeks ago. The notice, by definition, must be before the event happens. EEOC has provided a sample notice to tailor to an employer-specific program, and I'm about to ask our well-being folks about that in a second. Before I do, though, I just want to give a summary of the GINA authorization. GINA, again, it's not just notice, it's an authorization. The employer must provide prior and knowing, voluntary, and written authorization describing they know what type of genetic information is going to be obtained, what it's going to be for, what restrictions are, and saying, I authorize you, employer or wellness program as an extension of the employer, to do that And you cannot, as an employee, authorize it on behalf of your spouse. The spouse must provide their own authorization if their genetic information is provided. And dependent children, in terms of getting information, are generally off limits completely. But with that, I did want to ask our folks from our well-being wellness folks regarding what do you see with employers? Do they generally use the EEOC sample notice, or do they go other ways, or do they even know sometimes?
Yeah, thanks, Roger. And I'll keep this one short and sweet to keep us on track. But I would say the EEOC is one of the more standard starting points, if you will. We do see a lot of groups putting that in place. But one thing I want to point out quickly that we see is a lot of organizations will overlook the language, not realizing that it is a sample, it is a template. So while most of the language is going to stay consistent with what you need to stay compliant, there are areas of opportunity to tailor the language for your specific program. So it is an editable document that needs to be specified to what your program offers and entails. So I do want to point that out. And then beyond that, it's important for these protections. That's what the EEOC notices. It's about protections to become part of the company practices, policies, procedures. We really want to have those clear processes in place for employees to ask questions, access program information, submit that RES verification. We want to make that as easy as possible. And I recommend really reviewing every aspect of your program through the lens of these considerations in the notice. So read the notice and then really look at the details of your program to make sure that you are not only identifying potential pitfalls and weaknesses in the program that go beyond the EEOC notice, but also really putting those assurances in action. One of the trending topics that we're seeing in the well-being space is organizational trust. You've heard a lot about care probably over the last year or two, and safety, and now it's sort of morphing into that trust, that relationship between the employee and the employer. The EEOC notice and these other compliance authorizations are a great example of opportunities where employers can earn their employees' trust. But that's only if they align with that company's culture and employee experience. So I think that's a really important part of this conversation as well.
Thank you so much. And on the next slide, we just talked about the notices, we had that issue. And the next slide, we're going to talk about the allowable incentive amounts as well as voluntary. I'm not going to go into the details on this slide, the interest of time, but the short version is it took a little while for EEOC to come out with rules or an ideas of what they might consider to be an allowable incentive amount, so as that it's not high enough or low enough, depending on which way you go, that it removes the voluntariness. But they finally did in May 2016, and that was supposed to start in 2017. The AARP brought a suit against the EC on these rules, saying that these incentive limit provisions, which were generally speaking 30%, was okay. That's the very informal way of saying it. Said they were involuntary and coercive, saying employees who could not afford to pay the higher premiums would essentially be forced to do this. Court agreed with the AARP, vacated the provisions. The EEOC removed them January 1st, 2019, and everyone was waiting for the new ones. New ones did come out on January 7th, 2021, but they were not published in the Federal Register before the new administration, the following administration, Biden administration, took office and froze all as yet unpublished rules pending further review. And that's kind of where we sit today. So with that, since there's no guidance sitting out there on that, what does voluntary still mean? We know employers cannot require employees to participate. Employer cannot deny or limit health plan coverage for non-participation. Employer cannot take adverse employment action, etc. But how does the employer address incentive limits in the interim? Obviously, without a lot of guidance or any at all, really, the least risky approach is to offer no incentives. We do know that there are employers who have kind of said, well, you like 30% before, let's keep kind of doing that. That involves a lot of risk, could potentially result in legal challenges, And as per usual on these sorts of things, employers should review this issue with their legal counsel. Really quick though, for our folks, Doreen, what are you seeing out there in terms of these incentives? Have they kind of died down after that, or are they getting higher, lower? What are you seeing?
Yeah, it's a great question. I think on generally speaking, similar to the outcomes-based programs like we talked about, incentives do seem to be decreasing in the overall value. There's really mixed reviews around what is that magic number to drive engagement. So when we work with clients, we're really going to encourage them to stay well below that 30% threshold to minimize risk, but also because we're not seeing significant increases in engagement with larger incentives, generally speaking. There's an annual average amount that you'll see in some of the trend reports of around $600 per year for incentives as the average. So that's well within, the threshold under that 30%. And what I really encourage folks to think about is what are you trying to accomplish with your incentives, like we've mentioned many times already today. And we like to use incentives to sort of get employees through the door, so to speak. So capture their attention and help them become aware of the program that you want them to take advantage of, but not rely on that incentive for their full participation. Hopefully, once they're through that door, they'll be able to find aspects of the program that are meaningful for them, and they will choose to engage in that for their own intrinsic value that they bring. And so I think, we want to make sure that we're staying within the reason with a reasonable idea about what we think the limits might end up being. Who knows when they'll decide what those are going to be, or if they will even do that anytime soon. So we think we can stay well within the realm of risk by keeping it well under 30% and designing them well. So keeping in mind a menu of options for employees to participate in and not just one health outcome, for example. And then again, communicate things really, really well so that you can make sure the employees understand what's available. And that's going to have a big impact on whether or not you see engagement, in addition to some other factors like leadership buy-in and management support and things like that.
Okay, that's perfect. Thank you so much. Let's skip on to the next section, which is sort of a catch-all, additional compliance aspects. On the next slide, the taxation aspects. What we're looking at here is essentially this. What's the rule of income tax? Essentially, anything an employer gives an employee is subject to tax unless it falls into some kind of exclusion. Obviously, health insurance, that sort of thing, properly designed does. Wellness incentives generally do not. They will be taxable in most cases. That includes things like gift cards and so forth. Those are generally taxable. I'm going to move to the next slide again, in the interest of time. These slides will be available and you can look at the details. Remember the ACA affordability aspects of wellness programs. Obviously, we have to provide affordable care, affordable coverage, or offer it based on a level. If you have wellness incentives other than tobacco, an employer cannot count those for these purposes. Tobacco, generally they can, but you cannot say, well, if they got up to here and they got this wellness incentive, it would get there. Employers generally cannot count those. On the next slide, we'll talk about most of our scope here is on federal laws. Bear in mind, a few states here and there have a few laws that, when passed, may not have intended necessarily have anything to do with wellness programs, but kind of fell that way for some states. A lot of these are what called lawful product laws that prohibit discrimination in the workplace against employees who use tobacco or engage in otherwise legal activities. A lot of these came out in the early 90s during a lot of tobacco stuff, and some states will apply them to wellness programs here and there. So bear that in mind. A comprehensive discussion of that is beyond the scope of this, but always bear that in mind, particularly in the tobacco arena. On the next slide, we'll talk about taxation aspects. As we're talking about earlier, most wellness incentive rewards and so forth are going to be taxable if they're on value. And a big thing going on right now are what sometimes called wellness indemnity plans. There are these little things sitting out there, FICA savings plans and that kind of thing. And that's something we've been talking about because IRS has been talking about it. The IRS actually issued a memo on these plans recently. Most of them are problematic, to say the least. On the next couple of slides, I go into detail here, but I'm not going to do that in the interest of time and read everything. I would highly, highly, highly recommend, however, taking a look at these and listening to a podcast that was in our most recent edition of Compliance Corner with Suzanne Spradley and Chase Cannon, our Chief Compliance Officer and Deputy Chief Compliance Officer, respectively, have an excellent discussion of these different kind of plans that sit out there. And if you've been in this business long enough, you've probably talked to at least one vendor or someone purporting to be a vendor that they have found the magical formula for solving every employer's tax issues with these plans, and they are very, very problematic. So take a look at these slides and definitely listen to that exchange. It's about 20 minutes long. It really goes into details on these things. With that, we'll go to the next slide. Or the one after this, I'm sorry, after the Wellness Indemnity Plan. There we go. Final takeaways and resources. Again, in the interest of time, takeaways, we got the conclusions here. What I really want to do is I want to move to the slide toward the end where we talk about with our friends from the well-being folks from the Wellbeing Center about, there we go, the Wise and Well resources. And with that, I will pass that off to Doreen and or Sarah Beth.
Thank you, Roger. There's just so much to digest here, so it is really easy to run out of time, but I hope this has been helpful. And we want you to know that you do have additional resources available through our Wise and Well training center that is actually an employee-facing hub to access webinars. We also send out monthly newsletters and infographics through the Corporate Benefits Latest Insights email. So I want to flag that for everybody. It's got really great stuff in there, including a well-being section. And then for our employers, we do an annual well-being calendar. Our 2025 one has just been finalized, as well as a workplace well-being trends training each year. So really fascinating stuff in there. That'll be coming up in January. And then I want to make sure that everyone's aware of our next webinar. It'll be our last one for 2024. More good things to come in 2025. But it's going to be focused on holiday presents, how to increase connection while prioritizing self-care, which hopefully will be a relevant topic for everyone as the holidays are approaching. That's going to be on November 12th. So we hope you'll join, and that is not just for you, that is for all of your employees, available at no cost. And the recording will be in that Wise and Well Training Center as well. So thank you so much for indulging me. I've really enjoyed this conversation. And like I said, I hope there were some helpful tidbits and takeaways.
And I just want to add to that you'll receive a copy of the slides in addition to these great Wise and Well resources. We have a listing of our compliance publications. I know they're probably not as easy to read. We do try to interpret the laws and put it in easy read format as much as possible. But we do have a number of publications, including on the HIPAA non-discrimination rules, the point solutions. So hopefully you can take advantage of those as well. And you'll receive a copy of the slides and the recording if you do want to refer back to anything we discussed today. Thank you, everybody, for joining us today. We appreciate your participation and attention. And thank you, Doreen and Sarah Beth, as well, for joining the Benefits Compliance team.
Thanks for having us.
Appreciate your commentary. And with that,
Thanks,
I'll
everyone.
back to you, Amber.
All right. Well, thank you to all of our speakers for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you'll receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you, everyone, for joining us, and have a great day.